Yes, where were we?
We were
Underground.
point 8.2 in my presentation.
Yes. Right.
It occurred to me that...
Do keep your voice up, won't you?
My lord, yes, I will. It occurred to me that it might be of interest to your lordships to see how the 1923 Act was applied to a very closely analogous situation before the passing of the 1934 Act. Here, as I've explained to your lordships, we have a situation where Starr owns the wellhead and, in effect, the oil. Bocardo did not own the oil, but did own and was in possession, we say, of the land through which Starr passed their pipes to get to the oil. Now, as I referred to a little earlier, copyhold land produced this situation, which was the copyholder had possession of the surface and the land beneath, but property in the minerals was in the lord, just as here, property in the minerals is in the crown. And as I mentioned earlier, the 1923 Act was specifically targeted at the copyhold problem. Now, this was actually dealt with in a case which arose shortly after the 1923 Act was passed, which was a case called Re Markham Main Colliery. And it's in your lordship's bundles, in bundle 6 at tab 68. Bundle 6, tab 68.
Does it get a mention in your case?
It gets several mentions in my case. It is summarised, my lord, in Annex 2 to our case, where there's a short summary of what it says, which may be helpful to your lordship. And it is mentioned, the point I'm really dealing with arises on pages 12 and 13 of our case, where we refer to the case of Joycey, which tells you about the relative rights of the lord and the copyholder, which I set out in paragraph 38. And then I suggest that our present situation is analogous. And the case that is referred to in the footnote, Re Markham Main Colliery, is the one I was going to show your lordships. It's a decision of the Railway and Canal Commission, chaired by Mr. Justice Sankey, and it concerned the payment to be made for a right to work coal. The first part of the head note doesn't matter. The part that matters begins at the bottom of the first column, where it says the Markham Main Colliery applied under the above section, that's the section we're dealing with, for a right to work minerals at Armthorpe in Yorkshire and for certain residential rights. Some of the minerals were under copyhold lands of the manor of Armthorpe. Although the lord of the manor was entitled to the property in the minerals underneath the surface of the copyhold lands, the copyholders were entitled to the possession of them. And before the Act was passed, the minerals could not be worked without the concurrence of the copyholders. Held, the applicant should have leave to work the minerals on terms of paying proper compensation for the right to work the minerals, etc. On the question of the apportionment of the royalties between the lord of the manor and the copyholder, in the case of copyhold lands, no hard and fast rule could be laid down. All the circumstances must be taken into consideration. The Act was passed to prevent people from holding up coal by making unreasonable claims. On the facts of the present case, 2/3 of the royalty was to be paid to the lord of the manor and 1/3 to the copyholders, and the applicants were to be responsible for damage by subsidence. So the decision was that the copyholder, and all the copyholder had was the right to stop access. He had nothing else, didn't own the minerals, gets 1/3 of the royalty. The case was a case which did not involve getting in through the surface. It involved underground working, and one can tell that from page 254, first column, near the bottom of the page, last paragraph in the first column, where we are told the colliery company have already sunk a shaft from which they will be able to work the minerals in question, that shaft being situated about 2 miles to the east of Doncaster and 3/8 of a mile west of Armthorpe Church. So they were already down there and they were coming in from the side. What they wanted was an underground way leave. And if your lordships would turn on to page 257, on the previous page, Mr. Justice Sankey had referred to the Joycey case and the position that obtained between the Lord and copyholder. And halfway down the first column on page 257, he says that then, that being so, there is this impasse that the minerals could not be worked to the detriment of the national interest. So in the case of copyhold tenure, there was this great danger of minerals being hung up because the copyholder, in the landlord's opinion, asked too much. He gives an example of that. And he refers at the bottom of the page to what was known as the 50% rule, because there was a custom that proceeds were divided 50-50, because each party could, as it were, lock out the other. And then, in the second column on that page, on page 257, first paragraph break, he says, "I quite agree this act is not an act to confiscate rights, nor is it so interpreted by the court, but it is an act to enforce reasonable conduct with regard to rights. For example, suppose a man owns minerals, a small amount which is holding up a big coalfield, and wants, we will say for the sake of argument, £1 million for those rights. He could enforce his will before this act, with the result that the coal would be left unworked. In one way, it might be said, oh, well, that's his right, and he's entitled to it because he could get an injunction preventing anybody from interfering with the coal. But it's obvious in a case like that if it came to this court, we should naturally not give a man £1 million. Of course, I'm taking a very outside case to illustrate my point. For what it's worth, very much less. That is Mr. Manning's argument. He says, I think I ought to be entitled to what I think I could get before the act. That is the highest at which he put it. On the other hand, Sir Arthur Colfax, arguing on behalf of the Lord of the Manor, said, well, logically, all that the copyholder is entitled to get is support of the surface. What he had before the act was a right to prevent the landlord from taking the coal from underneath, as well as the right of support of the surface. Now he's been deprived of one of those things, namely the right to prevent the landlord from taking the coal, and therefore, logically, the copyholder is entitled to nothing for the right. But, says Sir Arthur Colfax, I don't want to take that point in this case, and I'm willing to say that he ought to have 20% of the royalty, not half and half, but 1/5.
Mr. Justice Peter Gibson says that's a very important reason why this
he does
case
indeed,
is different.
He does indeed, my lord. He says this case went entirely on a concession, and so it counts for very little. It's true, it went on a concession. But in my submission, that concession was absolutely right, because otherwise it would mean that somebody would get, as Sir Arthur Colfax said, absolutely nothing for what is in fact a valuable property right. So what actually happens is that the copyholder gets 1/3, that being considered a reasonable division. The Court of Appeal said that case was of very little help. As my Lord Collins has pointed out, Mr. Justice Peter Gibson distinguished it also. The trial judge thought it was instructive. He said he agreed that the position in this case was analogous to that in Markham. He says that at paragraph 85 of the judgment at first instance. And in our submission, the case is instructive. It does show that reasonable payment, merely for agreeing to give access, can be obtained by a landowner, even if he doesn't own the minerals. Ownership of the minerals is not the point, it's the ownership of the right of access. My Lord, I turn to the concept of willing grantor, willing grantee. There's quite a lot of authority on this, and what it means and what it doesn't mean. And
I'm terribly sorry to, just before we leave, this case seems to proceed on the basis that actually less should be paid following the act than before.
Well, my Lord, before the Act...
Because before the act there was just nothing to stop the chap saying, I want $1 million.
Yes.
Okay, it might not go ahead at that, but he could really drive an absolutely outrageous bargain if he
Yes.
could get away with it.
Yes.
But after the Act, not so.
My Lord, that's absolutely right. But not so because of the fair and reasonable criterion and the willing grantor, willing grantee criterion.
I know, but you say, as I understand it, that actually the Act means that you're going to get, if anything, more than you would have got without it, more than the original common law figure.
No. The common law figure is damages for trespass. Where one is suing for damages for trespass on the user basis, the courts have declined to follow the extreme line of saying, you could have locked them out, you could have asked for the moon and the stars, you could have got some huge exorbitant figure. The courts have not gone there. The courts have said, no, that's not right. When you have usurped somebody else's right by trespassing or breaching contract or whatever, you can only get what would have been agreed by reasonable parties in a negotiation, both parties being willing to deal. You can't get out and out red in tooth and claw ransom price. You can get a reasonable amount as between two willing parties, which is exactly what the Act provides for. Now, of course, apart from the Act, it might have been possible for somebody to be totally unreasonable, and indeed in some circumstances maybe to extract a very unreasonable price. But that is not the way in which the court approaches common law damages, and it's not the basis on which the Act approaches compensation. So the position discussed by Mr. Justice Sankey is saying this. It's saying the Act has moderated what you might otherwise have been able to do.
Mr. Justice Sankey is not addressing, is he, what the measure of damages would be for a trespass?
No, he's not. No, he's dealing with compensation under the Act.
Even Oberterm, in the bit about where he says that the coal would be left unworked,
Yes,
that assumes there'd be no trespass, that they wouldn't go on the land at all.
yes.
And the next bit, rather, doesn't suggest that you get £1 million under Lord Cairns's Act either.
No, it doesn't. No, you plainly wouldn't.
So that if you have the situation in which the owner makes a totally unreasonable demand, the one who wants the rights doesn't accede to it, but just goes ahead and does it anyway, then it may be, if the owner, either by delay or for some other reason, disentitles himself from an injunction, then you're going to be into damages under Lord Cairns's Act, as Lord Clark mentioned, and that would be on the basis of a negotiation between reasonable parties.
Yes.
So that the owner, having made an unreasonable demand and then not acted promptly, would end up, in effect, getting a fair price as equitable damages.
Yes, my lord, that's right. It wouldn't, I think, be necessary for the owner to have disentitled himself by delay or some other doctrine of equity from getting relief. Under Lord Cairns's Act, the question is not whether the plaintiff is entitled. So I'm sorry, I'll start again. Under Lord Cairns's Act, it doesn't matter. What matters is the exercise of the discretion. If in the court's discretion, the court would not grant an injunction, the court can still order damages in lieu of injunction, and the damages in lieu are the reasonable willing parties basis. If, of course, the plaintiff has disentitled himself from equitable relief altogether, then he doesn't even get damages in lieu, he gets nothing. He doesn't get an injunction and he doesn't get damages in lieu. There must be a jurisdiction to grant him.
Yes, of course that's right. In Rootham Park, it wasn't that the plaintiff had delayed too long. It's that the judge wasn't going to order perfectly good houses to be knocked down.
That's right.
It? Yes.
That's right. And that's made very clear in the case of Jaggard and Sawyer in the course of appeal as well.
Could I pick you up for your help on what the Court of Appeal says in paragraph 96 about Markham? The criticism that's made, I think, is that there isn't any proper discussion in Markham of Section 9.2 of the 1923 Act, which is the predecessor of Section 8.2 that we're thinking about. And that does seem to be right, because I can't find any reference in Markham to Section 9.2.
No, that's
there's no reference to it, and therefore there's no analysis of it. Where does
no,
that leave us? It's not going to
It's
help
certainly
us.
the section being applied,
Well, how do we know that?
because it's the compensation section under which they're awarding the compensation.
They don't mention it at all, I think.
I'm sorry, let me go back.
Everybody knew that.
I mean, it may have been assumed. It's rather elusive, because it was simply, unless I'm missing
Well, there is
something
no
somewhere,
other compensation
it isn't actually
section.
mentioned. But you say that is the whole substratum of the discussion, that it must be under Section 9.2.
Yes. Yes. I mean, they are constantly referring to the Act. It is true that they are not setting out the section with which no doubt they were very familiar, because they were dealing with this on a regular basis.
Yes.
And
Well, that may be, I mean, there's reference to somebody doing lots and lots of these cases. So perhaps, are you saying really that it was just understood, it didn't have to be said because everybody knew perfectly well it was a Section 9.2 case?
yes, well, it must have been a Section 9.2 case. That is the only compensation section that would have been applicable.
Yes.
It's the only one in the 1923 Act. So they must have been applying that. It's true that they don't embark on an analysis of it, but they are clearly applying the fair and reasonable criterion, where they reject the £1 million notion and say, no, the Act is to stop that.
So when we see page 257 near the top of the right-hand column, the passage about reasonable conduct with regard to rights, that really, are you suggesting that is really Section 9.2 being applied?
Yes, I am.
Well, 255, column 1, first paragraph. What we say is fair and reasonable. That must be referenced to 9.2.
It must be, yes.
Yes, I see. Yes. Yes, thank you very much.
Because you only showed us the part of this decision dealing with the division between the freeholders and the copyholders.
Yes.
I mean, there was another third party involved. That was the Markham Main Colliery Company, wasn't there?
Yes.
Because it wanted to come in, as you said, underground from some other land.
Some of the land, which was the subject of the application, was subject to copyhold tenure. Some was not. And there was an owner of the land other than the lord who owned the minerals and other than the ex-copyhold freeholder who was affected. So there was firstly the question of what royalty should they pay for the minerals. There was then the question of, as to the copyhold land, how should that be shared between lord and copyholder? And what I was drawing your lordship's attention to was the treatment of the situation where one party owned the minerals and the other party owned the land.
Well, so we go to willing grantor, grantee.
My lord,
basis,
yes.
do we?
I'm going to take your lordships to certain authorities, but I'll tell you what the propositions are that I'm seeking to establish.
Are they in the case?
They are in the case. Sorry if I can. This passage starts at paragraph 43 of the case and goes on to 53.
I didn't realise that higgling was a word all of its own. I thought it was a mistake for haggling. But
Well, I must say, my lord, I've always spoken of haggling, but Mr. Justice Donaldson, as he then was, called it higgling.
Yes, I think valuers use it as a phrase, don't they?
Yes, they do, and it occurs in the F.R. Evans case, and he talks about the higgling of the market. There we go.
I shall remember that when I'm next playing Scrabble with my son.
I'm sure he'll object.
But
Well, now, willing grantor or willing grantee. My first proposition is this, that when assessing compensation under the Act, the court is required to ascertain what fair and reasonable terms willing parties would agree, negotiating outside the statute. Because otherwise you get into a circularity. If you assume that the statute is there, saying, of course, you can go to the court and get this right, then the question merely arises again, well, what will the right cost you under the statute? What you have to do is put the statute on one side and say you've got two willing parties agreeing a fair and reasonable price. What would they do if the statute wasn't there? And that's exactly what Mr. Justice Buckley said in Associated Portland Cement Manufacturers application, which we cite at paragraph 45 of our printed case. It was a case on Section 9 of the 1923 Act. I'm not going to take up time taking your lordships to it, but it contains this passage. Section 9.2 requires the court in mandatory terms to assess the compensation or consideration on the basis of what would be fair and reasonable between a willing grantor and a willing grantee. The court is therefore directed to ascertain, as well as it can, upon what fair and reasonable terms willing parties negotiating outside the statute, that is, in a free market, would be likely to agree for a grant of such rights. That, in my submission, is absolutely right. It was doubted by the Court of Appeal in this case. And it's absolutely right, because the court doesn't take away the landowner's power to bargain. Indeed, as your lordships have seen, it's a precondition of an application under Ground D that he must be given a chance to negotiate, and he must be found, before the court has any jurisdiction, to be asking an unreasonable price. The description of the parties as willing shows that they're not, hypothetically, forced to buy or forced to sell.
Well, the way the court criticises that approach is to say that's not what the wording states.
Yes.
And you do find, as I'm sure you know, you do find sometimes in the statutory formula, a willing purchaser, willing buyer in the open market.
Yes.
That phrase is sometimes used, and it isn't here.
The expression in the open market is not used here. It's of some interest that the Secretary of State intervening submits positively that this means in the open market. And it's very difficult to see what it can mean otherwise than in the open market. The expression in the open market is usually meant to indicate that anybody is entitled to come in to bid who wants to. So it's an open market, it's not a restricted market.
Yes, I see. Yes.
Probably adds very little in this sort of context to say in the open market.
There's only one possible purchaser. In fact, there's a fixture, really. Each side can only be the...
There is only one possible purchaser, namely the oil licensee, whoever that is, the petroleum licensee.
I think the words in the open market do come into the statutory estate duty definition, which is in Inland Revenue Commissioners in Clay, the next
Yes.
case in your case.
Yes, they do. Yes, they do. And they I think they come into the Compulsory Purchase Act too, but I'm...
Yes, but then and you assume if it's an open market, you can put your stall out and all sorts of people can come and negotiate with you.
Yes.
It's that kind of feature where
Yes.
one isn't really in that position, I suppose you can say, in this case.
One isn't in that position. In this case, one isn't. But one could have that situation under the Act, of course, because if you're selling coal,
Yes.
selling a mineral, all sorts of people might want it. In the case of oil, there has to be a petroleum licensee who's got a license from the Crown.
Right, I
But
see.
in the case of other minerals,
Yes.
there could be a wider market.
What is it suggested that it means otherwise, on the other side, as it were?
I'm sorry,
Well, the construction of the statute. Between a willing grantor and a willing grantee, fair and reasonable. What is said on the other side that it means? If it doesn't mean what you said.
no, I'm not sure that there is much dissent from what I say about this point.
Well, the Court of Appeal, sorry to interrupt you, the Court of Appeal say it assumes, the formula assumes a compulsory purchase regime
Yes.
for compensation of bleak consideration. And they say, well, you've got to find, you see the statute and the allowance of at least 10%. And so the context, they're saying, dictates it's a statutory.
Yes, my Lord, I was feeling my way towards that. The point that's made against me is not that willing grant or willing grantee means something other than I say it does. It is that the point good principle comes into play to exclude from consideration the exploitation of the oil field. And so if you exclude the exploitation of the oil field, well, there's nothing really to sell.
Right.
That, I think, is principally how it's put against me, and certainly that is the ground of the decision of the Court of Appeal. That was the point of that passage where Lord Justice Aiken says, you know, what have I lost? Nothing.
Yes. And 1 iota.
Yes. I think the 1 iota comes from the judgment of Mr. Justice Peter Smith at first instance. So, my submission, what you've got imported by the words assuming willing party.
I mean, the plus for 10%, I would have thought, led to the conclusion, a more favourable conclusion from your point of view. You start with what you'd get without the 10%, and then you get another 10%.
Well, it does, my Lord, indeed. I mean,
So you first of all assess it without regard to the fact that there's compulsory service. And then you say, well, another 10% for good measure, as far as I can see.
Well, that's right. Another 10%, and maybe a bit more because of delay, cost, etc. The hassle factor.
So the 10% is because you're having to decide a price as a willing seller, where actually you might be an extremely unwilling seller.
Yes. It's a sort of it's a bit of a sop. I think
The
the Latin word was salated.
for having no option but to do the deal.
Yes.
You might in fact be intrinsically opposed.
Yes, well, you might, but you're assumed not to be.
But you're assumed not, but the price to the buyer and the value to you of that assumption is 10%.
Yes, but
10% uplift.
10% of nothing is nothing. It doesn't help very much if you've been deprived entirely of.
No, it assumes that it must be on the basis of some such other analysis.
Yes.
I mean, so you're not allowed to be as extortionate as you otherwise, without this formula of willing seller, willing buyer would have been entitled to be. You can't be extortionate as you could be as an unwilling. But there it is. So you have to arrive at what's a reasonable price, but then you get 10% on top for being precluded from getting an unreasonable price.
You can't be a dog in the manger and say, I won't sell at all.
Correct.
No.
And for good, no doubt, good public reasons. And as my Lord says, you get a quid pro quo of the 10%.
Yes. But my Lord.
Is it a quid pro quo for being a dog in the manger and not selling at all? Or is it a quid pro quo for not being able to get that additional extortionate amount that somebody who otherwise would be entitled to be a dog in a manger would be able to negotiate?
Maybe both.
It's really both.
Well, yes.
Well, Lord Justice Scott, who knew so much about this, and I'm just looking at Sparrow's, described it as the old sympathetic hypothesis of the unwilling seller and the willing buyer, which underlay judicial interpretation of the Act of 1845.
Yes, my Lord.
That's the way he saw it.
Yes. And it was something that had come in to compulsory purchase compensation awards, and which Lord Justice Scott, in the report that preceded the 1919 Act, said was unjustified, and so the 1919 Act, in Rule 1 of Section 2, cut it out. So it's very surprising to find it coming back in 1934, but it did. So that's my first point, my lords, that the negotiation that you're imagining for the purpose of the Act is a negotiation outside the Act. It's not a negotiation which is affected by the Act itself. And in my submission, Mr. Justice Buckley was right about that. The second proposition is that there is absolutely nothing in the willing grantor-grantee assumption to prevent the bid of a special purchaser being taken into account. I think that's pretty trite law from the point of view of valuation, but it was established in the case of Inland Revenue Commissioners and Clay. And the third principle, which is important for present purposes, because it goes to the root of the reasoning of Mr. Justice Gibson, is that the valuation is not to be approached by reference to the model of an auction, where all the buyer has to do is offer one bid above the rest of the market, who are bidding by reference to existing use value. That is a false approach to valuation, even in a case where there is a monopoly position, only one buyer. And that is established both by the Clay case and by what is conventionally called the Indian case, because nobody is quite sure how they would otherwise pronounce it.
Is that mentioned in your written case?
Indeed it is. Clay is mentioned at paragraph 46.
Yes.
And the Indian case is subsequently referred to in footnotes.
Which footnote?
I'm so sorry, my lord. I'm sure it is.
38.
I'm very grateful, my lord. Footnote 38.
Yes.
38.
Footnote 38.
The Indian case.
38, sorry.
My lord, I think it may be helpful to take you to Clay, which is a very familiar case, I know. It's in volume 5 at tab 60. This was a tax case, and my Lord Wolfe was right to say that the criterion for valuation was an open market sale by a willing seller. And the question of what was meant by willing seller had to be discussed. It was a rather curious case because it involved a residential property which was in fact bought by the next door nursing home at a figure of £1,000, which was higher than its value if it was sold simply as a residential property. The sale took place after the relevant valuation date, and so the question arose whether the tax should be topped up afterwards by reference to the later sale. The question arose as to what was meant by willing seller, which is dealt with by the Master of the Rolls at page 473.
Could you say the page again?
473.
473, yeah.
And then Master of the Rolls says, the other point is as to the meaning of willing seller. It's urged that Mrs. Buchanan never was a willing seller. She never wished to vacate the house in which she was living, and it was only after pressure from the trustees she agreed to sell for £1,000. I am disposed to think that a willing seller is a person who is a free agent and cannot be required by virtue of compulsory powers to sell, and that Mrs. Buchanan was a willing seller when in 1910 she voluntarily agreed to accept £1,000. So that's helpful. It stresses that a person, a willing seller, is not somebody who is required by virtue of compulsory powers to sell. He is not constrained to sell. And similar points are made by the other two judges, Lord Justice Swinfen Eadie at page 476. In the last paragraph, it was then urged that the vendor in the present case was not a willing seller. And then there's some reference to the facts of the case. And then in the last sentence on the page, a sale by a willing seller is distinguished from a sale which is made by reason of compulsory powers, where the vendor frequently obtains an addition to the price by reason of being under compulsion to sell. It does not mean a sale by a person willing to sell his property without reserve for any price he can obtain. It's pointed out to me by my own friend Mr. Beloff that about 8 lines down there is a reference to the word higgling about the price. So your Lordship can
Which page does he find that?
cite high authority to your son.
Page what?
It's page 477, about 8 lines down. There's a reference to
Oh, yes, yes.
higgling about price.
Yes, I see.
And there's another dictum about the meaning of willing seller in the judgment of Lord Justice Pickford on page 478. The penultimate paragraph. I think sold in the open market means sold in such a way that anyone wishing to purchase was able to do so, for example by auction or putting the house in the hands of an agent to sell. And I think a willing seller means one who's prepared to sell, provided a fair price is obtained under all the circumstances of the case. I don't think it means only a seller who's prepared to sell at any price and on any terms, and who's actually at the time wishing to sell. In other words, I don't think it means an anxious seller. So it's a person who's prepared to sell, provided a fair price is obtained.
My impression, reading the Court of Appeal while you've been speaking, is in paragraph 114, having got to the position which they have, which is that there is nothing in Bocardo's possession, as it were, that can be taken into account because they're losing nothing at all. But nevertheless, there's something to be taken into account as part of the formula as to what is fair and reasonable between a willing grantor and so on. So they're not disputing that part of it. The real issue seems to be what is the bargain, what is the subject matter that you're bargaining for?
Well, I think that's right.
I mean, you say, well, in order to find out what the subject matter is, you first of all got to look at the formula in the statute, and that tells you you're outside the compensation regime, and therefore you're bargaining for the right to enter the ground which the landowner can injunct if he doesn't agree to it. So it's a strange way of approaching it. I think they get to the willing seller having excluded pretty well everything that could be valued. And you're saying that's quite wrong because the statute assumes an open transaction at common law, as it were, outside the confines of the statute. Have I got your position correctly?
My Lord, yes, you have. We come at it by construing the statute we find before us and saying it uses these expressions have well-established meanings, they lead to the following conclusion. We then ask ourselves, is there some exclusionary rule or rule of construction, which means we have to construe it differently because there's an element here of compulsion. And we say, A, the rule doesn't apply, and B, even if the rule does apply, it doesn't have the effect that's contended for. Now, in other words, while I have this case open, clearly, it also casts some light on what I call the one more bid argument, an argument which was absolutely crucial to the decision of Mr. Justice Gibson. And we can see what their lordships say about that at page 476 in the judgment of Lord Justice Eadie. It's the penultimate paragraph, the one starting halfway down the page. It was then urged by the Solicitor General that if the probability of this special purchaser purchasing above the price, which but for his needs would have been the market price, could be taken into consideration at all, then only one further point or bid could be allowed, and it must be assumed that this special buyer would have become the purchaser upon making this one extra bid. Such an assumption would ordinarily be quite erroneous. The knowledge of the special need would affect the market price, and others would join in competing for the property with a view to obtaining it at a price less than that at which the opinion would be formed that it would be worth the while of the special buyer to purchase. And Lord Justice Pickford makes the same point at page 480, at the bottom of 479. He says, it is said that the only effect to be given to it, that's the wish of the trustees to buy, is that a small sum is to be added to the value of £750 to represent a final bid made by the trustees in order to acquire the property.
Sorry, where are we now?
I'm so sorry, my lord, at the bottom of page 479. The last paragraph there.
Yeah.
He says, this one more bid theory seems to me to be a fallacy and to ignore what is common experience. It assumes that the dwelling house, value £750, having been reached, everybody except the trustees will decline to make any further offer and allow the trustees to become the purchasers by a single offer, which exceeds that amount in however small a degree. And not only is there that decision, but there's also the Indian case, which also says the auction model is a fallacy, it's misleading. Now, the Indian case is at volume 8, tab 97.
So, I mean, the point about the one more bid and the fallacy is that actually somebody who doesn't want the thing himself will buy it in order to have the opportunity then of reselling it to the person he knows does want it and is prepared to pay more. I mean, it's as simple as that.
Yes. Well, that's the reasoning there. There's a rather different reasoning in some of the other cases, which says that somebody who wants something, like the trustees of the nursing home in that case, is prepared to pay what it's worth to him, and the other party negotiating with him, knowing what he wants it for, can force him up to that level, refuse to sell unless they reach a sensible level. So rather than putting it in an auction and accepting one more bid from the special purchaser, once he knows there's a special purchaser in the market, he negotiates with the special purchaser to acquire the price which the presence of the special purchaser merits. So it doesn't depend entirely on this question of other speculators coming and bidding the price up. I'm sorry, my lord, I think I may have given your lordships the wrong volume. I think it may be volume 7.
It is 8, I found it.
Oh, it is 8.
Yes.
Tab one.
It's tab 97.
The Indian case.
Oh, yes, right. No, I was right. It is bundle 8, and it is tab 97. Now, I have to confess that I think this is the most difficult case that has ever been decided.
That's saying something.
All the difficult cases were the ones that had to decide what it decided.
Yes. Well, that is true. But it does contain, in the speech of Lord Roma, some valuable passages. And if I could, it's a case about the acquisition of some land for a port, which land had the feature that it had a spring on it which would provide fresh water. But I resist getting involved in the facts, which are very difficult. What we do get at page 312 is a passage which applies Clay. At the top of page 312, having said that the Act in question was to the same effect as the Land Clauses Consolidation Act of 1845, Lord Roma says, the compensation must be determined, therefore, by reference to the price which a willing vendor might reasonably expect to obtain from a willing purchaser. The disinclination of the vendor to part with his land and the urgent necessity of the purchaser to buy must alike be disregarded. Neither must be considered as acting under compulsion. This is implied in the common saying that the value of the land is not to be estimated at its value to the purchaser. But this does not mean that the fact that some particular purchaser might desire the land more than others is to be disregarded. The wish of a particular purchaser, though not his compulsion, may always be taken into consideration for what it is worth. And then, so that goes to the meaning of willing vendor. At the bottom of page 314, Weald analyses the imaginary auction theory. And he says it's been suggested that in order to ascertain it, the arbitrator is to hold an imaginary auction. But with all respect to those who've made the suggestion, their lordships are unable to see how this is going to help the arbitrator. And then his lordship analyses the reason for that. It involves a rather interesting valuation concept called the Poremboki value, which as far as I can see is current use value. And at the bottom of page 315, apropos of this imaginary auction, Lord Raymer says, nor can the bidding be imagined to stop at the first advance on the Poremboki value, for the vendor is a willing vendor, and not one compelled by circumstances to sell his potentiality for anything that he can get. The arbitrator will therefore continue the imaginary bidding until a bid is reached, which in the arbitrator's estimate represents the true value to the vendor of the potentiality. The auction will therefore have been an entire waste of the arbitrator's imagination. If the value of the potentiality be X rupees, the imaginary auction will have taken place to ascertain the value of X from the imaginary bidding, and all that can be said is that the bidding will stop at X rupees. So, in other words, it's a complete waste of time.
Next paragraph is...
The truth of the matter is that the value of the potentiality must be ascertained by the arbitrator on such materials as are available to him, and without indulging in feats of the imagination. Requires some feat of imagination.
Must be feats of something.
Yes.
Just one Scottish judge thought there was something in the point, but it was rejected.
Yes. At the bottom of page 316, his lordship is dealing with the situation where there's only one purchaser, because the suggestion was being made, well, perhaps the auction model does apply where there's only one purchaser for that particular purpose. And he says, halfway down the last paragraph, it was contended on behalf of the respondent that at an auction where there's only one possible purchaser of the potentiality, the bidding will only rise above the Poremboki value, current use value, sufficiently to enable the land to be knocked down to that purchaser. But if the potentiality is of value to the vendor, if there happen to be two or more possible purchasers of it, it's difficult to see why he should be willing to part with it for nothing, merely because there's only one purchaser. To compel him to do so is to treat him as a vendor parting with his land under compulsion, and not as a willing vendor. The fact is that the only possible purchaser of a potentiality is usually quite willing to pay for it, and then he refers to clay as being an example of that. And before I leave this case, perhaps I could just draw your Lordship's attention to a section of the judgment which starts at the bottom of page 318 and continues 318, 318, yeah, and goes on to page 320. I won't try and take your Lordships through that, but it's of some significance because it's a discussion of a case called Lucas and Chesterfield Gas, in which rather different views were expressed by Lord Justice Fletcher Moulton and Lord Justice Vaughan Williams. Essentially, the debate was what happened if the only likely purchaser is the acquiring authority. And Lord Justice Fletcher Moulton said that his bid had to be ignored, and Lord Justice Vaughan Williams said it did not. And what Lord Raymer does on page 320 is disapprove the view of Lord Justice Fletcher Moulton and agree with the view of Lord Justice Vaughan Williams. Now, the reason that matters is that there is a case here on the Act called Re Naylor Benson. And it was relied on by the Court of Appeal, and it was relied on by Mr. Justice Gibson in Ryder. It's been disapproved here by the House of Lords, and by the Privy Council, rather. Re Naylor Benson was largely based on the disapproved dicta of Lord Justice Fletcher Moulton, which is virtually the entire ratio of the case. So I just draw that to your Lordship's attention. I won't take up time going through the whole controversy. What we have done in our printed case is we have included an annex at the back, which I expect your Lordships have seen, Annex 2, in which we have summarised the main decided authorities on the acts under consideration here.
And we get a reference to that case at page 59, do we?
Naylor Benson.
Yes.
Yes. That's right. It did largely depend on a decision in Re Lucas, and in the Indian case, Re Lucas's judgment of Lord Justice Fletcher Moulton, rather, is disapproved. As I say, I won't go over that controversy. I just point out that there is that connection between the various cases. My Lords, before I leave the question of willing lessor, willing lessee, willing grantor, willing grantee, there is another case, the Higgling case, the decision of Mr. Justice Donaldson at first instance in F.R. Evans of Leeds. I won't take you to it now because it is reviewed very carefully in the decision of His Honour Judge Haig in the Mercury case. But I'll just tell you a little bit about it. It was a case involving a very large industrial building called Walton Works, which was so large and so old-fashioned that nobody wanted it. There was no market for it. That was the evidence. But there was a rent review under which the tenant was deemed to be, as they nearly always are, a willing tenant. And the question arose, well, what do you do when you're told that there's a willing landlord and a willing tenant, but the evidence is that there's no market? And Mr. Justice Donaldson said, well, you've got to assume that the tenant is willing, even though he's not. And the evidence was the tenant didn't want the premises at all, and neither did anybody else. So the question was, well, what do you do in those circumstances? And the solution is that you assume that the tenant, because he's willing, does want it, and that the parties enter into a negotiation or higgling in which they both urge upon each other their various best negotiating points. One knows that at the end of the day they reach agreement because they have to, but that doesn't mean that they can't threaten to break off negotiations. They can. In the course of this imaginary negotiation, if one party is pressing its advantage too far, the other party can say, well, if that's how you feel, walk out. And the party that is pressing its advantage knows that the other party can walk out if it goes too far. Both parties know that about the other. And so they have to respect each other's points. They have to resolve their different negotiating positions. And Mr. Justice Donaldson goes through the various points which could be made in that case.
Well, it sounds like a feat of imagination to me.
It is a feat of imagination. He makes it quite clear it's a feat of imagination. But it's a very different feat of imagination to the auction one. It's what I call the locked room negotiation. Instead of imagining that the property is put on the market, put up at auction, and a whole lot of farmers are bidding, and one oil company, and the oil company only has to pay £1 more per acre than the farmers to get it, which is unrealistic. One assumes that the parties, there only being two of them, one who wants it and one who can sell it, are in a room, they negotiate, they reach a deal, but they don't know they're going to reach a deal. They fear that if they go too far, if either side is too greedy, the other one will walk out and say, no, I'm not going to deal on those terms. So the landowner can't ask too much, or he gets nothing, because the oil company says, fine, I'll go and drill an oil well somewhere else. The oil company knows that if it doesn't offer the landowner something reasonably approximate to what it's worth, then he'll walk out and he'll say, no, I'm not going to sell it to you for that. I know you've got £14 million worth of oil under my land. I'm not going to give it to you for a nominal sum. And your lordships will have seen actually how the award of the Court of Appeal is made up here. It's based on the evidence of Mr. Smith, who, relying on the decision of Mr. Justice Gibson in Ryder, said, well, the value of a deep tunnel, however long, however deep, however big, £50. Where did that come from? Well, where that came from was apparently the Channel Tunnel Act and the Olympic Park, which Mr. Smith had some knowledge of. He said, that's what you get for a deep tunnel, £50. But that, of course, is under the compulsory purchase legislation, where there are express prohibitions on taking into account the suitability and adaptability of the land for the purpose for which it's being acquired. So he takes his £50 and he then says, but there's oil under this land, so there's a special purchaser. So the special purchaser pay a bit more than the deep tunnel price. So I'll add 50%. Well, that's £25. And the Act says there's got to be another 10%, so I'll add another 10%. That takes me to 50, to 75, £82.50. That's it. That's the price under the Act. That's what you get. Now we say, just a minute, two parties sitting down together to negotiate the access to an oil field with £14 million worth of oil in it. The landowner is going to sell that for £82.50? Hardly. Hardly. That's ludicrous. And Mr. Justice Smith accepted that point. He accepted that a number of other figures, which were mentioned, £5,000, £9,000, were equally ludicrous. A landowner would just simply walk out. He would say, I'm not interested. You can't get your oil. It's not my problem. £82.50 was ludicrous. And £25 of that was attributable to the presence of an oil field under the land. Well, that is not what would happen in a real negotiation. Now, our submission here is therefore that this is in essence what one might call a classic key case. Some people call it ransom value, but that's a little bit pejorative. We say it's a case where we own a key to the treasure chest. It's not the only key. There are two locks on this treasure chest. One lock Star already have the key to, that is the petroleum licence. The Crown have sold them the key to that lock. But we have the key to the other lock, namely the right to come through the land. And so we are in a bargaining position. We will not sell our key for a nominal figure. We will not sell it for £82.50 because we have some notion of what it's worth to the oil company. If we're treated as willing to sell it for £82.50, the answer is we would not be willing. We would not remotely be willing to sell it for £82.50. And the grantee, the oil company, would be willing to pay what the key is worth to them. So a bargain takes place, a negotiation takes place, resulting in a bargain.
What it's worth to them, I mean, that isn't a full accounting to profits, of course.
No, it is not a full accounting to profits. Of course, they'll want to make a profit. Indeed, they will want the majority of the profit.
Yes.
It will be entirely reasonable of them to want the majority of the profit, because they are bringing more to the party than we are. And that was the basis upon which we approached this whole valuation exercise, and Mr. Crawford approached it. My Lords, we summarise for you what Mr. Crawford did in paragraphs 54 to 58 of our printed case. Your Lordships may in due course wish to read what Mr. Crawford says. I think that's a fair summary there. He considers the different factors which would weigh on the minds of the parties and be urged by the parties on each other in the course of the negotiation. He bears in mind that this is the optimal location for the drilling and the consequences of that. He considers the sort of deal an oil company would make. And what he said was, look, there are a lot of imponderables here. The landowner doesn't have access to all the data that the oil company's got. And the oil company is not going to give him all its data, because that gives away their bargaining position. So what they're probably going to do is they're going to reach a formula for payment. They're not going to reach a particular sum per annum. They're going to reach a formula which will be either a percentage of profit or a percentage of revenue. And by agreeing that formula, they will share between themselves the risks of how much oil there is, because there may be more than is expected, there may be less, and fluctuations in the oil price, which indeed were quite considerable over the period in question. So by agreeing a formula of that kind, they will avoid all those difficulties. And they can avoid a further difficulty by making it a percentage of revenue rather than a percentage of profit, because a percentage of profit brings into play all sorts of difficulties about calculating what is profit. Now, that was accepted by Mr. Smith, the oil company's witness, in evidence. That was all put to him, and he said, yes, I agree, that is the sort of deal they'd make, a percentage of profit. A percentage of revenue. And he also accepted, as the judge records in his judgment, that he accepted that BP and Ryder apart, the deal would have been 12.5%. Well, 12.5% was achievable by the landowner, I think was the way it was put. So that's the way we approached it. And the question then arises, well, what's wrong with that? And the answer that is made is BP and Ryder.
I don't think you need to take it to us, but Appendix 2, page 216 to 219, sets out the basis on which the 12.5% is arrived at.
I'm sorry, Appendix 2 to what?
It's Appendix 2. I'm just looking at the valuer's exercise.
Oh, yes.
And, I mean, there's a certain amount of experience built into this. It's not a figure plucked out of the air. It's based on various arguments and assessments and so on.
Yes, it is. I mean, he works it out. He works through it. And then he says, as I think we've recorded in our case, paragraph 58, he considers a sort of comparable, and that he considers payments made by landowners for access to coal.
Yes.
And he does a cross-check there. He looks at the payments. He has a schedule which sets those out. And he says, well, they average 7.6% of the price of the coal. Yeah. But there's a bigger gross margin on oil than there is on coal. And so if you adjust for that, you get a figure of between 10% and 14%. And his figure is 12.5%. So he says, I seem to be in the right area. I mean, it wasn't guesswork. It was done by working through a process of reasoning, which he set out, and cross-checked with such comparable information as he could find. So the fly in the ointment at that point, there having been, at any rate for a time, a trial, although Mr. Smith tried to row back from it, but there having been an apparent degree of consensus between the valuers, the question was, what is the effect of BP and Ryder, and was it correctly decided? Now, BP and Ryder was a claim, it was the first claim under the 1966 Act about the exploitation of oil to go to court. It may even have been the only one, I'm not sure. And it concerned BP's oil field at Wych Farm in Dorset. It's a very big oil field. I think it's the biggest onshore oil field in Europe. The report is at volume 3, tab 35. My learned friends in their printed case invite your lordships to read this case with some attention, which I'm sure your lordships would have done in any event, and we support that. It is quite a difficult decision, quite a difficult case. It's quite dense. It is extremely careful. I mean, one can only pay tribute to Mr. Justice Peter Gibson's care in going about this analysis. It involves a number of different rights, ancillary rights, which were being sought under the Act. And your lordships can see those rights on page 237. They do not include drilling rights under somebody else's land as such. They include a number of rights to make use of the surface of land, and one of the sites is well sites.
It's what?
Well sites. Item number 2 on page 237 is well sites.
Right.
They wanted 10.5 acres for the purpose of exploiting petroleum as an extension to some existing well sites. At any rate, there are quite a number of different ancillary rights which are there being sought. Now, the evidence was that the agricultural use value of this land was £40 an acre. And you can see there that page 242, letter J, just below letter J, it says, in the light of the evidence of Mr. Christopher Payne's, giving the rental value of the agricultural land required by BP is between £35 and £40 per acre, BP is content to take the higher figure of £40 per acre. So that's your agricultural use value. The landlord's case was that the value based on comparables, which the oil industry were paying at that time, was £2,500 an acre. And that's at page 242L, just a little bit further down the page. Mr. Edmund gave evidence of other transactions entered into by BP for the acquisition or exploration and production sites, and on this basis his valuation was £2,500 per acre. And the judge, in case he'd got it wrong, when he awarded £45 an acre, considered an alternative valuation on the basis of market value. He begins that at page 250E, where there's a heading, Alternative Market Valuation. And at 251K, after considering the evidence about that, he says, just opposite letter K, having regard to all the evidence, I would assess the appropriate rent on this basis for the well sites, gathering station, pumping station, water supply compound and access road at £3,200 per acre. but his decision was £45 per acre.
Where's the 3,200?
I'm sorry, it's page
Just below K.
251, just by letter K.
Thank you. So he,
Now, what?
you say the decision, where do we find that set out?
Well, we can certainly find it in the head note. No, we can't find it in the head note. He does, in fact, decide £45.
248K.
I'm very grateful to you, Anna, that's very kind. 248K, that's right.
Oh, yes. Yes.
Fair and reasonable to give effect to the presence in the market of the special purchaser by increasing the consideration of the rights over the additional land now sought from £40 an acre to £45. Now, BP must have thought Christmas had come. They were offering much more than that, as we see when we turn to the decision on costs. And it would appear that there was a huge premium at the time, before this case was decided, over agricultural use value for oil land, if you call it that. Now, we criticise this decision, which on the face of it looks rather surprising, on two principal grounds. The first is that the learned judge appears to have regarded the landowner as having been entirely stripped of his bargaining power when it came to assessing compensation. And in connection with that, could we first look at page 244E? We find the passage as a reference to Mr. Essayan's submissions, and then the next sentence, Mr. Waller contended that the compulsory acquisition principles had no application. He submitted that those acts had not expropriated the right of the landowner to bargain by reference to that to which the land gave access. Absolutely my argument. And that the statutory language supported the view that the Land Clauses Act principles had no application. In particular, he stressed the importance of negotiations in the statutory scheme and pointed out that there was no express exclusion of any factor that would naturally enter into negotiations between a willing grantor and a willing grantee, and that Section 8.2 was not concerned simply with compensation for loss, and he contrasted the language of the 1962 Act, under which the Minister is given power to authorise the compulsory purchase of land, or make a compulsory rights order, that's the Pipelines Act, in which event it is expressly provided that compensation is to be assessed by reference to the depreciation of the value of the interest. Now, how does the learned judge respond to that? He says at the bottom of that column, I do not find Mr. Waller's arguments persuasive. To my mind, he attaches too much importance to the negotiations as a guide to what the court would assess under Section 8.2. And he points out that the first three grounds for applying under the Act, in Section 3 of the 1966 Act, envisage circumstances where there will be no negotiations, but the court must nevertheless assess compensation on the same basis as if the application is made under Ground D. Now, in my submission, that's wrong. A willing grantor-grantee basis posits a negotiation, and it is a precondition of an application on Ground D that there should have been a negotiation in which the landowner is being too greedy, because if he's not being too greedy, the court has no jurisdiction to entertain the application. In my submission, Mr. Waller was not attaching too much importance to negotiations. That is exactly what Section 8.2 is all about. But Mr. Justice Peter Gibson goes on, and at page 247F,
(247F).
in fact, I think 247E is
yeah.
a better starting place. 247E. Mr. Waller listed what he described as 3 critical factors to be taken into account in considering whether a landowner has made unreasonable demands and in assessing consideration or compensation. The first is the factor that the land and the right to sink boreholes provide access to the oil. I accept that's an intrinsic quality of the land, that oil lies underneath it. But the fact that access to oil is being provided is relevant only insofar as it affects the value of what the landowner loses by the grant of rights. The oil is not his to lose. It is possible to sink boreholes to obtain access to oil on other land adjacent to and not comprised in the well sites. Well, only up to a point, and in theory it would be possible to let such alternative sites and grant like rights to others. But in reality there will be no takers for such purposes. The true key to the oil is the license granted to the licensee, giving him and him alone the right to bore for and produce oil. The presence of oil will cause the licensee oil company to be in the market for the rights. The landowner's right to extract a high price from the oil company by virtue of his power of veto to prevent the oil company coming onto his land becomes irrelevant once the compulsory powers of the 1966 Act are invoked. Now, in my submission, well, it's quite clear from that the learned judge is treating the bargaining power of the landowner, that is the power to say, you cannot come onto my land, as irrelevant. Hence his decision. And as not part of what the landowner loses by the grant of these rights. He's saying the key to the oil is the petroleum license. And the landowner's bargaining power is not a key at all. But in my submission, that's a mistake. So he says, in the next paragraph, or next paragraph but 1, at 247H, in my judgment, therefore, the correct basis of valuation under Section 8.2 of the rights to be acquired is the value of what the estate will lose by the grant, that is to say, the rights over land having its existing agricultural and forestry use, plus compensation for disturbance and injurious affection. It's just existing use value. And that's £40. But then there's another factor, which I'll come to. So he has treated, in effect, as irrelevant the factor which, in the present case, gives my right, my power to grant a right, actually the whole of its value. That is, the right of access. Now, in that case, of course, he was dealing with surface rights, and so his award didn't have quite the remarkable result that it would have in the present case of reducing compensation to essentially a completely nominal amount, £82.50. But he was taking away from the consideration the most valuable aspect of the rights which were being granted, namely the rights of access to oil. So that is the first ground on which we criticise Ryder. He has treated, the learned judge has treated the bargaining position of the landowner as an irrelevance.
How does he get there? He's building it up from, is it from Associated Portland Cement or?
No, Associated Portland Cement is rather against him on that.
Yes.
I mean, he gets there for the reasons he gives in the two passages I've just cited. I mean, he says to Mr. Waller's point at page 244, when Mr. Waller says the Act hasn't expropriated the right of the landowner to bargain. And the judge says, well, Mr. Waller is putting too much emphasis on negotiations. That's his answer.
But he says section 3.2a, b and c envisage circumstances where there would be none.
Yes. Well,
that's probably right.
My submission misses the point.
Yeah.
Because the point is that under 8.2, one is simply asking the question, if you have a willing grantor and a willing grantee bargaining, what would be a fair price for them to agree? That's the question. Now, to say, well, under section 3, there are certain circumstances where you can go to court without negotiating first, doesn't meet that point at all. Certainly there are some situations when there are lots and lots of people who are affected, or where you can't find the landowners, or where the landowners don't have legal capacity to grant what you want to grant. It's perfectly true, there are all those circumstances. But the fact that there are those circumstances doesn't touch this point at all.
Well, it's his point about the value to the grantee being irrelevant, isn't it?
Yes.
Which you say is wrong.
Well,
because the value to the grantee is a measure, at least, of what the grantor can obtain at a negotiation.
Yes.
Indeed, that would be his only point, really.
Yes.
At the negotiation.
At the negotiation.
Look,
yes.
this oil is going to be $14 million to you. I'm not selling it for 10p.
Yes. That's absolutely right. It's rather interesting that when we come to the point good principle, which features in Ryder, the judge doesn't apply it. And I'll show you that in a moment. So that's not the solution in Ryder. His reasoning here seems to be this argument that the Act has not expropriated the power to bargain is overemphasising negotiation. That's what he says in the first place. And subsequently, he says, well, the key to the oil isn't the right of access through the land, it's the petroleum licence. But I say, well, yes, the petroleum licence is one of the keys, but you need a second key to this chest, and that is the right to go through the land.
Page 244H, the sentence just below it, shows what's really at the heart of his argument, I think, which he says it'd be very surprising if the general principles of compulsory acquisition, which have the merit of common sense, do not apply to this particular form of compulsory acquisition.
Yes.
So that's really the anchor of his argument, I think.
Yes, my lord, that's right. He does hold that the principles of compulsory acquisition apply, but interestingly enough, he then doesn't apply the critical principle, which is point good, as we'll see. I mean, if point good applies, and if the scheme that has to be ignored is the exploitation of the oil field, well, the oil company doesn't have to pay any more than a farmer does. What's the £5 for? But the extra £5 is because of the oil field, as we'll see. So he reflects the value of the oil field, but he gives it a one more bid value. There's a piece of reasoning which, in my submission, it's rather difficult to follow.
So where are we going now, the Indian case?
Well, could we go next to page 248K, which my learned friend referred us to a moment ago. This is the second fallacy, as we would put it. What the judge does here is he applies the auction model, which had been criticised in Clay and the Indian case. And he says, at page 248K, Mr. Sayan submitted, this is just above K, that if the licensee as a special purchaser is to be taken into account, an additional 5% would be appropriate as being the something more envisaged in the Cedar case as being payable. I would assess the addition a little higher than that for him to be certain that he'll acquire the right he seeks. In my judgment, it would be fair and reasonable to give effect to the presence in the market of the special purchaser by increasing the consideration for the rights over the additional land now sought from £40 to £45, subject to 3-year rent reviews tied to the value of agricultural land in southwest England. So there he is, simply adding one more bid to, or one more bid and a bit, to the value of agricultural land.
Where's he doing one more bid?
Well, he's
40 to 45.
40 to 45.
He doesn't say anything about bids, does he?
He does, in fact, because he considers it. He distinguishes the Indian case.
He says, I would assess the addition a little higher than that.
Yes, he does.
To be certain that he will acquire the rights. So something a bit more than the agricultural value.
Sorry, I must look at my other copy of this case. Which I've
Just one above K.
Right.
The reference to Cedar goes back to the Privy Council case at the foot of 243 and the top of 244, I think.
Yes, it is. My Lords, as far as the Indian case is concerned, he deals with that at the bottom of the first paragraph of 248. It's 248F. He says much reliance was placed on it by Mr. Waller, and the Privy Council held there was only one purchaser, the acquiring authority. The special adaptability of the land to the water supply. It was held the fact did not mean that no or only a negligible value could be attributed to the water supply, and then he sets out other parts of the decision. And he says it's right to acknowledge the Privy Council in that case did not approve of the concept of estimating value by reference to imaginary auction, at which the special purchaser would put in a bid only just sufficient to beat those bidding on the basis that the land had no special value for them. But if I may say so with the greatest respect, the description of the imaginary auction which Lord Roma gave to reject its concept is one which is apt only where there are competing special purchasers and not a single special purchaser. It is, of course, not the only way one might imagine the best price is being achieved, but it's a concept commonly employed. See Cedar. And for my part, in a case such as the present, I think it useful. In the real world, the willing special purchaser would bid a price sufficient to make sure he would beat all who are acquiring the lands for their existing use. I cannot see the logic of a purchaser, however willing, being assumed to pay a price far in excess of other bidders. The willing grantor is to be assumed to be willing to sell at the best price he can obtain, and he cannot be assumed to insist on a reserve price measured by reference to some value other than what is fairly and reasonably obtainable in the market. So, essentially, what the learned judge is doing is distinguishing the Indian case on the ground that here there's only one purchaser. But there was only one purchaser in the Indian case, and Lord Roma specifically dealt with the problem introduced by only one purchaser and considered it explicitly in the Indian case. And that is not a ground for distinguishing the Indian case. And as was emphasized in the Indian case, and also appears from the F.R. Evans case, this imaginary auction is a fallacy. Two parties negotiating, one of whom knows, roughly speaking, what it's worth to the other party, will reach a deal in that negotiation without an auction. You don't have to have an auction to get a price. If the landowner thinks that he is being diddled, he will walk out. And he would expect the other party to come after him saying, no, we didn't mean it. We would like to do a deal with you after all at a higher figure. So that approach, which says the auction is a helpful concept, is, in my submission, not a sound approach. The final and third point I would make about BP and Ryder is that there is something of an oddity here. It appears at page 247J. This is just after the paragraph at H, where the judge has said that the correct basis of valuation is existing use value plus disturbance and injurious affection. And then he says, I come now to the question whether the special interest of an oil company like BP in acquiring rights will cause the value to exceed existing use value. In valuing those rights, Mr. Essayan submitted the fact that the licensee has a license and that the rights have a special value to him fall to be ignored because of the point good principle. Mr. Wallace submitted that the special adaptability or adventitious value of the land is, even on compulsory acquisition principles, apart from the 1919 Act, not to be ignored, but is reflected in the value, and that land providing access to oil is land having a special adaptability or an adventitious value. I accept that the fact of BP obtaining compulsory purchase powers for the purpose of exploiting the oil is to be disregarded, but I do not see why the fact that the presence of oil and gas in the Witch Farm oil field gives to the licensee, but only to the licensee, a special interest in acquiring the rights should be ignored. It would be unreal to ignore the fact that the license has removed all competition from the other oil companies, but has made the licensee a possible purchaser of those rights because of their special value to him. That special value will be reflected in the value to the estate of the rights, because the licensee would be prepared to pay more to secure those rights than those interested in purchasing the land only for its agricultural or forestry value. So the learned judge appears to be saying, well, Mr. Essayan says point good means no uplift above agricultural use, but that's not right. I have to reflect the fact that there's an oil field there which makes the licensee, although he's the only person in the market, pay more. So he's not applying point good. Point good says, if you'd pay more because of the scheme, and the argument must have been that the exploitation of the oil was the scheme, you don't get that extra. You don't get the enhancement of value. But the judge gives an enhancement of value, so he's not applying point good.
Yeah, but does he explain why then he only added £5?
Well, he only...
In the light of that analysis?
Well, in the light of that analysis, he only adds £5 because of the one more bid theory. You've got a market which consists of a lot of farmers who want the land for agriculture. You've got an oil company, but only one. There's an auction. The farmers all drop out, and the oil company gets it for another £5. That seems to be the thinking, despite the fact that the evidence showed that before that, oil companies would pay £2,500, or as the case may be, £3,200 for these rights.
He's noted point good at page 243, just below letter M. But I don't see anywhere here an express recognition that he's departing from it. I mean, it's included amongst his principles.
Yes, well...
but I mean, I can see the force of your point, but it's curious it doesn't say point good doesn't apply, and I'm deliberately not applying it.
Well, he doesn't say in terms point good doesn't apply.
Does he say?
But the argument addressed to him at 247 was on the basis that point good did apply, and that the effect of point good was that the value to the oil company, the special value, had to be ignored. And he says in the next paragraph, no, the special value doesn't have to be ignored.
Yes. But in arriving at the £40, he seems to have applied the point good principle. I mean, he may not have done when he came to decide how much to add to the £40, but the reason he started with £40 was because of the, or in part, because of the point good principle. So at that part of the analysis, he was applying the principles, including the fourth principle, as I said.
My Lord, I think that's right.
Hence the fact that he could say at the bottom of page 247 at F, the left-hand column, his second factor.
Yes.
He was concerned that he might defend against the principle that the value to the grantor what he lost, not the value to the grantee that is relevant.
Yes.
And so at that part of the analysis, but then we'd have this rather odd further reference you've just referred to.
Yes. So, on the one hand, the value to the grantee is said to be irrelevant, and then at 247J, it's taken into account. But it's taken into account so as to only achieve a one more bid consequence.
Yeah.
Well, my Lord, there is, of course, in the judgment a consideration of earlier cases. We have explained in an appendix what we say about the decision, apart from these points that I've mentioned to your Lordships. I don't want to take up any more time with your Lordships at this stage. We have set out our criticisms there of the detailed treatment of some of the authorities. But I'm not sure that it will assist you at all to take you through that, unless your Lordships wish me to.
From your order of submissions, I see point 12 is criticisms of Ryder and Mercury. Are you going to deal with that?
Yes.
Yeah.
That's next.
Yeah.
Now, my Lord, I can't really take any credit for devising the criticisms of Ryder that I've made, because they are all made by His Honour Judge Haig in the Mercury case. The Mercury case, and we give your Lordships a summary of that in our Annex 2, was a case about the Telecommunications Code, which contained a similar but not identical provision for compensation. And the argument addressed to the court by Mr. Aiken's counsel was that the telecommunications company ought to pay only a nominal sum for the right to run cables under a private road because of Ryder. He said, well, this right has no value, and we have to ignore the scheme. We have to ignore what the cables are for, and on that basis, the landowner wouldn't mind. He wouldn't be able to sell these rights to anybody else for anything. And His Honour Judge Haig didn't accept that. He was able to distinguish Ryder because the words of the Act are slightly different. But he considered Ryder, and he said that although he would feel bound to follow it, had the matter been free from authority, he would not have decided the case that way. Mercury is to be found in Volume 6 at tab 70. Because this has been printed off a website, it has different page numbering to that of the report, which is a bit trying. But at page 8 of your Lordships...
I see Mr. Aikens appeared for the plaintiff.
Yes, indeed he did. I think
They're seeking to uphold Mr. Justice Peter Gibbons's analysis.
He was. And has subsequently succeeded in doing so. He deals at page 8 with the meaning of willing. He has a heading, authorities on willing, but in the paragraph before that heading, he says this: in my view, the word willingly in paragraph 718 cannot be taken in isolation, for it is a meaningless concept if considered apart from the financial terms of the grant. Whether or not a vendor or grantor is willing must necessarily depend on the price or consideration he is to receive. Thus, a vendor cannot sensibly be stigmatized as being unwilling because he refuses to accept an offer at an inadequate price. Willing must mean willing to sell at a fair price. Likewise, given willingly must, in my judgment, mean given willingly for a consideration which is fair and reasonable. In his submissions, Mr. Akins argued that ex hypothesi, Liddy was not willing because it would not give consent to the proposed grant except on what he described as its own prohibitive terms. In my judgment, that does not advance the argument and is logically fallacious, because it begs the real question and indeed really assumes what it is setting out to demonstrate. And the learned judge then goes on to consider the authorities on willing, and he considers Clay, and he cites various passages from Clay, which I've cited to your lordship, and he considers the Indian case, and he cites various passages from that, and he considers F.R. Evans. So Clay is number 1, Indian case number 2, F.R. Evans number 3. And he sets out various passages for that, which I won't read out to your lordship, but I'll invite your lordships to consider. He then considers various submissions from Mercury as to compulsory purchase principles and their application. And at page 14, in the penultimate paragraph, after considering BP and Ryder, he says, had the matter been free from authority, I would not myself have considered that the compulsory purchase principles were applicable to the 1923 and 1966 Acts. I would have held that the relevant principles was those derived from the phrases willing grant or willing grantee and fair and reasonable discussed above. These are, of course, in many respects very similar to, and to a large degree overlap, the compulsory purchase principles. In most cases, the practical result is likely to be the same. But I cannot myself see any justification for going beyond the former principles and introducing further concepts which Parliament refrained, presumably intentionally, from incorporating into the legislation. Nevertheless, had the present case been one under the 1966 Act, as the Naylor-Benson case has been strongly challenged, followed in the BP case, I would have considered myself bound to follow them in that respect, on the Colchester Estates principle. That's what he says about that. He then goes on the next page to consider the application of compulsory purchase principles, if they are applicable, and the point good principle. And he says under the heading point good principle, he says, it follows from the foregoing that the point good principle in compulsory purchase on which Mr. Room and Mr. Akins place reliance has no application. However, I heard a good deal of evidence and argument relating to it, and for the sake of completeness, I propose to make some comments and finding about it in relation to the case. And then he explains what it is. He then says, halfway down the next page, what is the scheme underlying the acquisition in the present case? Various suggestions were put forward on behalf of Mercury, including Mercury's license, national network, or the provision of telecommunication services to the whole Docklands area. I agree with Mr. Hobson that these suggestions are too wide. In my judgment, the scheme must be confined to the provision of telecommunication services to the Canary Wharf development, and I so find as a fact. However, in my judgment, the premium value of the right to lay cable ducts was pre-existent to the acquisition of the right. The Tameside Earth Station and the proposal to develop Canary Wharf both existed before the acquisition. Following and applying the dicta of Lord Justice Mann in the Batchelor case, even if the compulsory acquisition principles had been applicable, I would have found that the point good principle was not relevant, and so account had to be taken of the special value to Mercury of the proposed grant. I should mention that although Mr. Justice Peter Gibson in the BP case mentioned the point good principle, as I read his judgment, he did not consider it applied on the facts of that case. And he refers to a passage where the learned judge has said, I do not see why the fact that the presence of oil and gas in the Wych Farm oil field gives to the licensee, but only the licensee, a special interest in acquiring the rights should be ignored. That's the passage I read to your lordships. That is clearly correct, and in accordance with the dicta of Lord Justice Mann. The existence of the oil field and the value of the surface rights to exploit it plainly were pre-existing to the acquisition of those rights. In my view, the situation is the same in the present case. Well, I adopt and invite your lordships to apply that approach. But then the learned judge goes on, factors affecting quantification of the special interest. And he says, in the BP case, evidence was given of annual sums paid for similar rights in comparable cases, which were greatly in excess of and bore no relationship to agricultural values, which were the existing use values. Although, as mentioned above, he considered that the consideration for the grant should properly reflect the special interest of the licensee.
Sorry, I'm lost now. Where are you now?
I'm so sorry, my lord. Bottom of page 17, heading Factors Affecting Quantification.
You're just reading that last bit, sorry. Yeah.
Thank you. He says, Mr. Justice Peter Gibson felt able to disregard that evidence. Instead, he returned, with some enthusiasm, to the concept of an imaginary auction, notwithstanding its rejection by Lord Raymer in the Indian case. And then he says what Mr. Justice Peter Gibson said. On that basis, the judge decided that the consideration should be just something more than the agricultural value of the land, and he fixed it at £45 per acre, an increase of 8% over the agricultural value of £40 per acre. This compared with the landowner's valuer's figures based on the comparables of £2,500 per acre. Mr. Akins relied on this part of Mr. Justice Peter Gibson's judgment and argued I should adopt a similar approach. I am unable to accept that argument, and I must respectfully decline to follow this part of Peter Gibson's judgment for the following reasons. And then he gives 6 reasons. He says it's inconsistent with Clay and the Indian case. He says it appears simply to resurrect the one more bid argument, which has been decisively rejected in those cases and others. He says the fallacy of the argument is exposed if one postulates a property which is of interest to only one purchaser or grantee, i.e. a property with a negligible existing use or porumboki value, such as a factory constructed or adapted for the special use of a particular tenant, or of such a size as to be of interest to only one tenant, as in F.R. Evans. On the one more bid argument, the vendor or grantor would sell or let at only a nominal or very small figure, without regard to the value to the purchaser or grantee. In my view, on that basis, it would plainly be a driven or forced vendor or grantor, and not a willing one. Fourthly, the fallacy of the argument is also exposed by considering the case of a grant of a right-of-way or way-leave agreement, our case, which will cause no detriment to the landowner. If there's only one possible user of the way in question, runs the argument, the person wishing to acquire the right-of-way will only have to offer a small consideration, which the landowner will therefore be obliged to accept. The logical consequence of this, it seems to me, is that the consideration will be the same whether the right-of-way is for the purpose of a small cottage or a large mansion or a factory. That is plainly absurd and contrary to all experience. In practice, the landowner is able to negotiate an appropriate consideration, which can take one of several forms, and then he sets those out. The landowner is able to do so because he's able to take into account in his negotiating stance the importance and value of the proposed right to the grantee. If he's forced to disregard these factors, he will, in my view, again cease to be a willing grantor and will become a driven or forced one. And then he refers to the facts of the BP case, the figures, and he says, making every possible allowance for the strong element of anxiety on the part of the grantee to get the right, I have to say, in my view, the disparity between the £45 and the £2,500 borders on the absurd. And I find it impossible to see how the grantor would be considered willing at the former figure. Sixthly, he says, in his comments on Stokes and Cambridge, Mr. Justice Peter Gibson expressed the view that that decision could only be justified on the footing that there was more than one possible purchaser of the ransom strip. This view again appears also to depend on the one more bid argument. With respect, that is a novel suggestion, and it finds no support in the decision itself, nor in the recent decisions in the Court of Appeal, in which the Stokes and Cambridge principle has been considered by the Court of Appeal, namely the Batchelor case and the Ozanne case. And indeed, there is nothing in Stokes and Cambridge which suggests that the adjustment there made had anything to do with there being more than one possible purchaser of the ransom strip. So, Judge Haig was, of course, very experienced in valuation matters. He wrote the book on leasehold enfranchisement, and he was very experienced in compulsory purchase and compensation matters.
The fact that the telecommunications industry hasn't challenged this decision in 16 years shows that it's commercially acceptable.
Yes, it does. What he goes on to do is look at the market and then apply the criterion of fair and reasonable.
Well, that chapter, is it?
That's
I'm conscious a bit of the time because you're 4.5 hours. Strictly
Lord,
speaking,
I'm
we run
conscious
out.
too.
But we don't need to hold you very precisely to it, but I think we should try to make a little more progress if we can.
Certainly.
Point 13, are compulsory purchase principles applicable? We've really been dealing with that at some length, haven't you?
I've already dealt with that this morning.
Yes.
If I can just summarise it. As I suggested to your lordships, we say the right approach is construe section 8.2. To look over one's shoulder at the construction of different words and different statutes, albeit that the subject matter involves compulsory acquisition, is a potentially dangerous approach. It's not, in principle, a correct approach. There are very substantial differences to the regime introduced by the Compulsory Purchase Acts. There are some similarities. The intervener stresses the similarities. In our printed case, we identify quite a lot of differences. But what I think is quite clear is that Parliament did not see fit to incorporate by reference the provisions of the Compulsory Purchase Code and the various valuation rules. On the other hand, I have to accept that this section says that the result has to be fair and reasonable. It's fair and reasonable between a willing grantor and a willing grantee. It's not necessary to go to point good in order to show that what is intended here is that the landowner should not be overcompensated. Of course he should not be overcompensated. The section says so. It should be a fair and reasonable amount. But that doesn't involve completely ignoring the purpose for which the right is wanted. I don't propose to say any more about whether compulsory purchase principles apply. That essentially is my case on that. Now, what happens if point good is to be applied, or if something like it is to be applied, or some aspect of it is to be applied? Now, it has been authoritatively established by a recent decision of the House of Lords that even under compulsory purchase statutes, value can include key value. And this was dealt with in the case of Waters, which was the case about the Cardiff Bay Barrage, where in order to create the Cardiff Bay Barrage, which would destroy wetland habitats for seabirds, it was necessary to provide, by acquiring property on what were called the Gwent levels, alternative wetland habitats. And the question was whether, in assessing compensation for the wetland habitats on the Gwent levels, one regarded that as part of the Cardiff Bay Barrage scheme, which had to be disregarded, or not. Now, it was held that it was part of the scheme, and it was disregarded. But the relationship of key value, which is what I've been talking about, to point good, was explained and considered by the court. Waters is at volume 9, tab 100. I've wholly mislaid volume 9. However, it's It's paragraph 64 of the judgment of Lord Nichols. With the convenient heading ransom value. One last point should be noted before returning to the present case. This concerns so-called ransom value, or less pejoratively, key value. I've already mentioned that under the value to the owner principle, or the point good principle, whichever nomenclature is preferred, the pressing need of an acquiring authority for the subject land as part of a scheme should be disregarded when assessing its value for compensation purposes. The value of the land is not the price a driven buyer would be prepared to pay, but a strip of land may have a special value if it is the key to the development of other land. In that event, this feature of the land represents part of its value as much for the purposes of compensation as on an actual sale in the open market. The intersection of these two principles was identified neatly by Lord Justice Mann in Batchelor. If a premium value is entirely due to the scheme underlying the acquisition, then it must be disregarded. If it was pre-existent to the scheme, it must, in my judgment, be regarded. To ignore the pre-existent value would be to expropriate it without compensation and would be contravene the fundamental principle of equivalence. In the present case, the claimants contend their land had key value because of its importance as a compensatory wetlands required for completion of the Cardiff Bay Barrage project. Whether this contention is well-founded for compensation purposes depends, in accordance with the principle enunciated by Lord Justice Mann, on the ambit of the scheme of which the subject land's acquisition was an integral part. And then there is a consideration of that on the facts. My Lord Brown alluded to the same question at paragraph 140, where Lord Brown said, true it is that in the Indian case, Lord Romer said, the disinclination of the vendor to part with his land and the urgent necessity of the purchaser to buy must alike be disregarded, neither must be considered as acting under compulsion. It by no means follows, however, that the open market value to the seller will exclude whatever key value the land may have. On the contrary, any such value properly falls to be taken into account, as it was in Stokes and Cambridge, where the Lands Tribunal, determining the value of land compulsorily acquired by the corporation, recognised that the landowner would himself have had to pay the key value of other land in order to realise the development potential of his own, and reduced the valuation of the order land accordingly. The recognition of the land's key value to a particular purchaser is merely an extreme manifestation of the approach taken in the Indian case. So there's nothing in the compulsory purchase code or the point good principle which precludes the reflection in the valuation of key value.
So it makes no difference then, does it? I mean, all the previous arguments irrelevant, really, is it? Because it's still, you get the same answer on either.
You get the same answer, provided that the value was a pre-existent value or due to pre-existent circumstances.
What does that mean?
Well, it's quite difficult. If the value is generated by the scheme, as it's called, and the scheme is a pretty elusive concept, and if the value is generated entirely by the scheme, then you have to ignore it. If, on the other hand, it was there anyway, you don't have to ignore it.
So does that mean, in this case, on the facts, we know the oil was beneath the ground?
The apex of the oil field was under Bocardo's land.
It was always going to have to be got at by means of some kind of piping or whatever it was through Bocardo's land. That's been there from the beginning of time, in effect, since it all got there.
Yes.
But does this depend on knowledge at all?
No. No. I mean, you'd have to assume for these purposes that the parties knew about it, because otherwise it wouldn't be reflected in value. But there's nothing in the principle, in the point good principle, which says anything about knowledge.
So the scheme is really taking advantage of something that was
there already.
And I suppose your submission is saying, well, this has nothing to do with the oil itself, because of course that doesn't belong to the landowner, but just the fact that it was on his land and can only be got at by some kind of a way leave through the land.
That is exactly what I say, my lord, yes. This is not value generated by the petroleum license. It's not value generated by an application to the court for a right. It's not it's assuming there had been one, which of course there hasn't. The value is not generated by any of those things. The value is there already. The reason that the landowner can bargain for a price for allowing access is geographical. The oil is underneath him. Now, there's one case which I'd like to refer you to, but I find I don't have the reference to it. It's the Chapman and Chichester District Council case, which is a Lands Tribunal case, but it gives a very close analogy to this.
439.
39, thank you, 439.
I think after we've dealt with this case, we'd better stop, Mr.
Yes, my lord, I'm almost home.
Sorry?
I'm almost home.
Almost home,
I've
right.
got two short topics.
Yes.
My lord, the point here was that there was a piece of wasteland which was the access to a development site on the backland. And the question arose as to the application of the point-good principle. The acquiring authority wanted to get access across the wasteland to land for the housing development. And what gave the land its value was, that is, the wasteland its value, was its geographical position and the lack of any other suitable access to the housing land. This is a decision of the tribunal. Mr. Wellings, I believe, yes, it was Mr. Wellings. And the passage in question is on the last page, page 4, where in the long paragraph on that page, of course, regard must be had to the needs of the particular purchaser, that is to say, the actual purchaser, namely the acquiring authority, which is, of course, an authority possessing compulsory purchase powers. Nevertheless, the question whether the needs of the authority for the reference land as access to the rear land are peculiar to itself cannot be determined unless the needs of other possible owners are considered. I'm sorry,
It's really quite close to the bottom of the paragraph, isn't it?
Yes. That is right, it is further down. Under reference to page 680, I accordingly hold the acquiring authority's needs for the reference land as access to the rear land are not peculiar to itself. On that basis, Rule 3 doesn't apply. It appears to me that the reference land is the key which unlocks the development value of the rear land in whosoever's hands the rear land happens to be. By reason of that fact, the reference land has acquired naturally a value in excess of its existing use value. The matter can be tested by analogy with the point-good principle, as was done by the Court of Appeal in Lamb. It is not the scheme underlying the acquisition which gives value to the reference land in excess of its existing use value. It is its geographical position, coupled with the fact that there is no other suitable access for residential development on the rear land. Now, that is directly comparable to the present case. Here, it's not the scheme of acquisition of a right of way through our land which gives the land its value. It's its geographical position between the oil company's land, where they have their wellhead, and the apex of the oil field. So
I understand this case by saying that it may very well be there would have been others interested in developing the backland behind this waste access strip. And it's that that gave it the pre-existing key value. But if the only possibility of developing the backland, and therefore of giving this additional value to the wasteland, was a compulsory purchase order, well, then it would have been a different result. Isn't that what it's?
No, my lord. I think what the tribunal is saying is that is a matter that hasn't been investigated and doesn't matter. It doesn't matter who wants the backland. It doesn't matter whether it's A or B or C or whoever wants it.
So long as there are other candidates for wanting it.
No, it doesn't turn on whether there are other candidates.
Well,
It's whoever wants it.
Well, I think we may have to come back
Would have required access.
tomorrow once we thought a bit more about it.
Yes,
Can I mention, just for Mr. Beloff's assistance, I know that he's got the Human Rights Act point on his list of things to deal with. At the moment, their lordships, having had regard to paragraph 13, I think it is, of the respondent's case, are not likely to be persuaded very easily that it's a point worth developing. I mean, you obviously can try, but I don't think at the moment we're very keen to get deeply into the subject.
Open to development, as it were, admissible, or simply in terms of its merits?
Well, we haven't actually ruled that you can't argue it, but at the moment, I think you should assume we should deal with it very lightly, shall I put it that way?
In accordance with your lordship's ruling.
Tomorrow morning at 10:30.